All right. Good afternoon, everyone. My name is Karen Scale, and I'll be hosting the second quarter policy guidance webinar. We have a lot of interesting and informative letters to talk about today. So we'll get started in just a minute. Uh, I'll go over some housekeeping. I will introduce the speakers and the respective letters that we'll be discussing today. I'll also, at the very end of the webinar today, I'm going to put a link in the chat for a very short 5-question survey where you can provide some feedback on the webinar. So that we can better serve you. And if there's things you'd like us to cover, we can do that. So we're going to give it another minute or so. I think we have about 200 people registered today, and I see about half are in. So we'll get started in just a moment. And if you have any questions, you can put them in the chat, and we'll get started in just a few moments. All right. Can everyone see my screen and hear me okay before I actually get started? Yes, perfect. All
Yes.
right. Thank you very much. Okay, everyone. So we're going to go ahead and get started. This is the second quarter policy guidance webinar. We do these every quarter, and the goal is to discuss some of the letters that might need a little bit more explanation or clarification. So if there's any information or things you would like to see in the future, we do have a short 5-question survey at the end. If you have questions, you can put them in the chat and we'll address those as we go forward. All right, so without further ado, I'm going to go ahead and get started. So a few things, the webinar is going to be recorded. So if anybody has an objection about having this webinar recorded, you can just let me know in the chat and we will stop the recording. Also, I did send out a copy of the PDF slide deck about 15 minutes prior to the webinar. So that should have come in your email. If you did not receive a copy of the slide deck, for whatever reason, I can send that immediately following the webinar, and you can just send me a quick email. There's a link on the very first slide to my email address, and I'll be happy to send that forward. And then, yeah, as I mentioned, the surveys at the end of the presentation. And once again, just go ahead and raise your hand or put your questions or comments in the chat. So today we have a few letters to discuss. We're going to be talking about ACL 2617. This is dual agency foster family agency administrative rate. We're going to be discussing ACL 2619, notice of action forms for the new foster care tiered rate structure. ACIN I0626, this is CBCAP allocations. ACL 2589, exclusive tribal justification and transfer to tribal court. And then lastly, we're going to do ACL 2562, SB 603, updates to children's advocacy centers, multidisciplinary teams, and child forensic interview recordings. Okay. All right, so the first letter that we're going to talk about today is ACL 2617, Dual Agency Foster Family Agency Administrative Rate. This is presented by the Foster Care Rates Policy Unit System of Care branch. So whenever you're ready, you can just go ahead and take it away and we'll get started.
Sure thing. I'm John Hale. I'm from Foster Care Rates Policy Unit, and I'll talk a little bit about ACL 2617. And this is regarding children and non-minor dependents who are dually served. And for those who are not as familiar, children and non-minor dependents who are eligible to receive regional center services and who are recipients of the following programs are referred to as children and non-minor dependents who are dually served. In the past, they were known as dual agency children and non-minor dependents, but we have switched over to a different terminology. It's still called the dual agency rate, though. The programs that this applies to are children who receive AAP, KINDAP, ARC, AFDC foster care, and children who are living with non-related legal guardians. So dually served children who are placed by a county or a tribal placing agency who are in a non-vendored home-based setting are eligible for the dual agency Lanterman rate or the dual agency early intervention rate, depending on their eligibility criteria. And it's important to note that although some children under age 3 can receive the dual agency Lanterman rate if they're determined to have a permanent disability, developmental disability, it could be eligible under 3. However, in order to receive the dual agency supplement, they would have to be 3 years of age or older. Next page, please. So before we get into ACL 2617, I want to talk about ACL 2404. Now this ACL supersedes ACL 817, which was the original dual agency rate ACL, because it omitted FFA resource families as a placement category that's eligible for the dual agency rate. This 2404 was to correct that oversight. So youth who are in an FFA can receive either the dual agency rate or the level of care rates or ISFC. Whichever rate is higher is what the resource family should receive. So they will need to, of course, be assessed for their level of care, as are all home-based placements need to be assessed for the level of care protocol. Let me see. Yeah, so and then one thing that that we added, because FFAs, of course, have an administrative expenses and responsibilities, we set the administrative rate for the dual agency homes. We set the administrative rate to be equivalent to the basic rate. Next page, please. So expanding on ACL 2404, this ACL 2617 is kind of correcting that FFA admin amount. Because CDSS has received a lot of feedback that this was disadvantageous to some dually served youth because they were receiving services from the FFA, which were now receiving a lower rate than they would have through the level of care protocol. So the additional support and needs that the FFA was providing was not being accounted for in their portion of the rate, and especially with the ISFC rate, which includes ISFC services. So I mean, it could make those ISFC services go unpaid for or just not provided. So this ACL 2617 was to address that issue. Yeah, and so in order to determine the appropriate FFA admin rate, you would complete the level of care protocol as you would anyway. And then you would take the corresponding admin rate to that level of care level, and that would be the admin rate for the dual agency rate. I have a chart on the next page, I believe, that should hopefully explain that a little better. Yeah. So here's a breakdown of how the dual agency rates work in combination with the FFA administrative rates. So if we look at the dual agency early intervention rate chart, the second row down, the early intervention rate, as you can see, is the same. So that's the rate that gets paid to the caregiver. So 1525 is the caregiver rate. However, the FFA admin rate increases. So that's the admin rate that that the FFA would have received through the various level of care rates. So they would have normally received for level of care 3, for example, an admin rate of 1408. And because they were previously dropped down to the basic rate amount, that's what caused the problem. So so a youth who is assessed to be level of care 3, the home would still receive 1525, but the administrative portion paid to the FFA would be 1408. And same thing if you go over a couple columns to the ISFC rates. As you can see, it's a much significant difference compared to the basic rate, and that's because the FFA is providing ISFC services, and they need compensation for that. So that's how those charts work. And then, of course, the other chart next to it, the dual agency Lanterman rate, is just the same thing, but with the Lanterman rate in the second row there is, of course, higher than the earlier intervention rate. Yeah, I mean, for the most part, that encompasses ACL 2617. Go to the next page, but that about covers it. I have my email address here if you have any questions about this. And yeah, thank you very much.
Right. Thank you very much, John.
Mhm.
All right. And like I said, if you have any questions, you can put them in the chat. Even if you think of something later, any questions that were not addressed in the webinar today, we can go ahead and look at those and reply later if that's what happens. All right. So we're going to go ahead and move on to the next section. And this is ACL 2619, Notice of Action Forms for the new foster care tiered rate structure. And this is going to be presented by Kelly Walker from SOCB.
Hi there, everybody. I've been introduced, Kelly Walker. I'm from Rates Policy. I work with John, who just spoke on dual agency. And as Karen said, I'm here to talk about ACL 2619. To prepare for the new foster care tiered rate structure, or the TRS, we worked with a work group to release 9 specialized notice of action forms, or NOAAs, that will go into effect with the TRS implementation date of July 1, 2027. These forms are going to be fully integrated and available within the CalSAWS template repository. They aren't automated quite yet, but they will be there by the TRS implementation date of July 1, 2027. Next slide, please. So like I said, there's 9 NOAAs. Each of the 9 NOAAs, they are called the NA 404 A through I form series. They are linked in the ACL, and each of those links will take you to our department website where the NOAAs are currently housed. And right now, our translation unit is very busy translating each of those 9 NOAAs into 20 different languages as we speak. We did get the Spanish back, so we're down to 19. So we still got quite more to translate, but they will be ready for the implementation date. And just as reference, initial guidance on the on TRS was provided in ACL 2494. Next slide, please. So for part of our due process, adequate notice must be provided, and adequate notice is our notice of actions or NOAAs. And there are two different tracks you can take to have a NOAA be generated. And there's a rate action trigger, and that is if a rate is granted, increased, denied, decreased, canceled, discontinued, or terminated. And this does include strengths building and immediate needs funding. The second track you would take is if a new IP CANS is completed. Adequate notice must be provided. And even if there is no change in a tier as a result of the IP CANS, NOAA will still go out as a no change. Next slide, please. And this is just a list of all of our NOAAs, the form numbers, the applicable placements, and the scenarios, like I mentioned above: rate approval, change, discontinued, denied, and no change. And this is the various placements. Next slide, please. We have dual agency, SILP, THP, NND, and KingGap. And I actually noticed right before this meeting started, there was a NOAA inadvertently left off of this. It is called the post-rate hearing. And essentially that NOAA is for a state administrative law judge can order a new IP CANS assessment if there was a disagreement with the previous CANS assessment. So that was left off. My apologies. I just noticed it. So it's a post-secondary review. State ALJ can order a new IP CANS to be done if there was a disagreement. Next slide, please. This is just some various contact information and links. All of our forms are linked on the Forms and Brochures webpage. Our applicable ACLs are linked. System integration, like I said, CalSAWS is working to automate to go live July 1. The NOAAs will be in the Learning Management Job Aid section in the CalSAWS template repository. And if you guys have any questions or need additional information, you're welcome to email Rates Policy or myself, Kelly Walker, at dss.ca.gov. And yeah, that's about it for the NOAAs. If you have any questions, you can put them in the chat, or like I said, feel free to email myself or the Rates Policy box.
Thank you, Kelly. I do notice there is a message from Janine, and there's a question: will these be ready to be uploaded into CARES?
We are currently working with CARES and SAWS in a work group, so that is the intent.
Thank you. All right, thank you very much. We'll go ahead and move on to the next letter. And this is ACIN I-0626. This is the CBCAP allocations, strategies, and reporting requirements. And this is going to be, presented by Crystal Singleton. Thank you.
Thank you, Karen, and excuse me, everyone. Anyhow, my name is Crystal Singleton. As Karen just mentioned, I work in the Family and Community Support Services unit. Today, we're going to be talking about ACIN 0626, and it talks about the CBCAP funding, and it supports child abuse and neglect prevention efforts throughout California. Allocations are based in part on county birth certificate revenue fees reported through Apricot system. Counties must also accept terms and conditions in Apricot to receive the funding. And as you see on the screen, funding supports primary and secondary prevention activities only, so tertiary is not allowed. So you cannot use the funds for that. Some examples of that funding, those prevention levels are family resource and support programs, parenting education, voluntary home visiting, and community-based prevention initiatives. Funds may also be used to support local comprehensive prevention plans, strategies. Yes, sorry, I seen something pop up on the screen. And then also some key priorities and reporting requirements. Counties should engage community partners, tribes, parents, and youth with lived experience, and also focus on improving outcomes through evidence-based and evidence-informed practices. Some annual reporting must include parent leadership and family involvement, outreach to special populations, collaboration with prevention partners, and description of services that are funded. CBCAP outcome goals. Of course, you have to fulfill federal tracking mandates by documenting everything that I just mentioned. Next slide, please. And here's just a depiction of the allowable use of funds. And as you see on the top, tertiary is not eligible for use of CBCAP funds, but secondary and primary is eligible, and you can use the funds for those. Next slide, please. So the total funding that we received for this fiscal year is 3.5 million. And so 3.4 is allocated to the counties and that are opted in, excuse me, not opted in, to the counties. And then the tribal allocation is 60,000. And as I mentioned, funds are released upon the county trust fund, birth certificate revenue, and also the federal award letter. And that is all I have. I believe next slide. Any questions, you can contact the OCAP P&D there on your screen. And that is all that I have. Thank you.
Thank you, Crystal.
You're welcome.
Okay. Our next letter is ACL 2589. This is tribal jurisdiction, and this is going to be presented by Amelia Franson from SPEIB. Oh, okay. Let me see if I can unmute you. Hold on. We're just having one moment, please. I'll unmute. One second. One moment. I'm a little slow on my laptop. Here we go. Okay.
Okay,
You
can you hear
should
me
be
okay?
good. Yes, thank you. Thank you. Sorry about that.
Oh, no, it's okay. By chance, does the camera work as well? It's not letting me turn on my camera either.
Let's see. There we go.
Okay, great. Can you see me okay?
Yes, thank you so much.
Thank you. Okay, good afternoon, everyone. My name is Amelia Franson, and I'm an analyst in the Family Intake and Engagement Unit of the Children and Family Services Division at CSS. I'll be presenting on ACL 25-89, exclusive tribal jurisdiction and transfer to tribal court. Purpose and background. The Indian Child Welfare Act was enacted in 1978 to protect the best interest of Indian children, their families, and tribes. The ICWA establishes minimum standards for state court proceedings, including dependency, delinquency, probate guardianship, and family court proceedings involving Indian children. However, states and counties inconsistently applied the ICWA. As mentioned, California has incorporated and expanded upon minimum federal ICWA standards adopted and clarified by the Bureau of Indian Affairs, BIA, in 2016, with the passage of Assembly Bills 3176 and 2944. The goal of AB 3176 was to create a statewide standard for ICWA. California statute dictates that county placing agencies have responsibility to meet the ICWA standards in order to ensure the safety of California's Indian children and help Indian children remain safely in or return to their homes whenever possible. In 2006, when California incorporated the federal ICWA into state law, the state legislature outlined that there is no resource that is more vital to the continued existence and integrity of Indian tribes and their children. The state of California has an interest in protecting Indian children who are members or citizens of, or are eligible for membership or citizenship in an Indian tribe. The state was committed to protecting the essential tribal relations and best interests of an Indian child by promoting practices in accordance with the Federal Indian Child Welfare Act of 1978. AB 81 further updates California statute to reflect federal ICWA requirements and reinforce protections for Indian children, families, and their tribes. Next slide, please. This recorded webinar covers the sixth and final ACL in a series addressing the Indian Child Welfare Act, or the ICWA and its requirements. This ACL provides guidance to county child welfare service agencies and county probation departments regarding amendments to Welfare and Institutions Code, Section 305.5, made under Assembly Bills 3176 and 2944. These amendments were created to align state law with the requirements of ICWA and ensure a higher standard of protection for the rights of parents or Indian custodians of Indian children, consistent with 25 United States Code, Section 1921. The focus of this particular ACL is on exclusive jurisdiction and transfer of cases to tribal court and what these requirements mean for counties when working with Indian children and families. This webinar offers a high-level overview of key points. It does not replace reading the ACL itself. Participants should refer to the ACL for more complete details and guidance. The ACL covered today is part of a broader series that expands on the policies introduced in ACL 20-38. All letters in the series provide additional clarification and implementation direction. For this session, we'll be focusing specifically on ACL 25-89, which addresses exclusive tribal jurisdiction and transfer to tribal court. Next slide, please. Tribal exclusive jurisdiction. Under the Indian Child Welfare Act, specifically Section 1911 of Title 25 of the United States Code, tribes have exclusive jurisdiction over Indian children custody proceedings when the child resides or is domiciled on the reservation. Tribes may also reassume jurisdiction under Section 1918, meaning jurisdiction returns fully to the tribe. If a child is believed to be a ward of a tribal court or resides or domiciled where the tribe exercises exclusive jurisdiction, the social worker or probation officer must immediately document all efforts to contact the tribe and confirm jurisdiction. Once confirmed, the case must be transferred to the tribe's custody and jurisdiction. As emphasized in the ICWA desk reference, many Indians located in California may be citizens of tribes located in other states, and these tribes may hold exclusive jurisdiction. When the county receives a referral involving an Indian child, the social worker collaborates with the child's tribe during the investigation. Once the tribe confirms that it will exercise jurisdiction, the social worker documents this in CWS SMS. There will also be a section dedicated to ICWA documentation and cares, where these documents can be uploaded. After documentation, the county closes its investigation as the tribe exercises exclusive jurisdiction. The county then receives the tribe's response and uploads it into the case management system for documentation purposes and completes the investigation closure. In practice, the delivery service log is the only designated location to document that communication was completed. Social workers and probation officers must maintain copies of all communications and keep accurate records. All contacts and activities should be thoroughly documented, including the fact that communication occurred. Social workers and probation officers are responsible for documenting progress and including all relevant information in their case notes. Practice exceptions include documenting every contact and maintaining a clear, complete record of communication. Rules of exclusive jurisdiction apply to Indian children who are members or eligible for membership in a federally recognized tribe, consistent with the ICWA requirements. Next slide, please. Tribal exclusive jurisdiction continued. Domicile for a parent, Indian custodian, or legal guardian. Domicile is the place where the person is physically present and considers their true, fixed, and permanent home, the place they intend to return and remain indefinitely. For an Indian child, the child's domicile is the domicile of the parents, Indian custodian, or legal guardian. If the parents are unmarried, the child's domicile follows that of the custodial parent. Next slide, please. Tribal exclusive jurisdiction continued. When a social worker or probation officer has a reason to know a child is an Indian child, they must use due diligence to identify and contact the child's tribe as required by MPP Section 31-135.232. Written notification is essential because it helps the tribe determine whether exclusive jurisdiction applies. However, receiving written notice does not by itself establish that exclusive jurisdiction exists. The tribe makes that determination. The written notification must inform the tribe that the child has been taken into protective custody, a petition has been filed, the county is requesting confirmation of whether the child is already a ward of the tribal court or under the tribe's exclusive jurisdiction. The written notification must include the child's name and date of birth, name of the parents, guardians, or Indian custodians, date of removal, a request for confirmation of wardship or exclusive tribal jurisdiction, a statement that the social worker will notify the state court once the tribe provides confirmation. This communication ensures that the tribe has a meaningful opportunity to assert its jurisdictional authority. Please keep in mind there is no state-required form for this notification. Statute requires that the notification to the tribe must be in writing. The format of the notification may vary by county, tribe, or individual case. MPP Section 31-135.235 does not prescribe to a standardized format. Tribes may also request additional information regarding the child's identity, family, or circumstances of removal to verify the child's status or jurisdiction. Next slide, please. Ceding jurisdiction in cases with exclusive jurisdiction. Ceding jurisdiction refers to the process of which a state relinquishes its jurisdiction over a child dependency case. Under the ICWA California law, a tribe has exclusive jurisdiction when the child is a tribal ward or resides or domiciled on the reservation of a tribe exercising exclusive jurisdiction. The social worker or probation officer must actively contact the tribe and confirm whether the child falls under exclusive jurisdiction and document all efforts. Once confirmation is received that the exclusive tribal jurisdiction applies, the social worker or probation officer must promptly notify the juvenile court and move to dismiss the case, as the state no longer has authority. The caseworker or probation officer must work with the tribe to ensure the physical transfer of the child occurs consistently with local protocols agreed upon the county and the tribe. After tribal confirmation, the social worker or probation officer is generally expected to transfer the custody and jurisdiction within 24 hours. Please note, there's no specific form that exists for providing written notification to the tribe. The format of this communication is not prescribed in statute and varies across counties, jurisdiction, and individual practice. Statute only requires that the notification be in writing, and specific information is listed in the MPP Section 31-135.235. When exclusive tribal jurisdiction exists, the case must transfer to the tribe. Each tribe has its own procedures, confirmation formats that are not standardized and may differ from tribe to tribe. If the agency receives a confirmation of exclusive or existing tribal jurisdiction after a dependency petition is filed, the agency must immediately notify the court and all parties and seek dismissal of the dependency proceeding. Next slide, please. Concurrent jurisdiction. Concurrent jurisdiction is when an Indian child does not live on the reservation, is not a ward of the tribal court, meaning both tribal and state courts have authority. Even in concurrent cases, federal law presumes tribal jurisdiction and reflects preference to hear cases in tribal court. While the state has jurisdiction, it must still fully comply with ICWA procedural and substantial requirements. In urgent situations, a county may take temporary action to prevent imminent harm, but this should be short-lived and replaced by tribal proceedings when possible. The state or local authority shall ensure that the emergency removal or placement terminates immediately when the removal or placement is no longer necessary to prevent imminent physical damage or harm to the child, and shall expeditiously initiate an Indian child custody proceeding transfer to the child to the jurisdiction of the Indian child's tribe, or restore the child to the parent or Indian custodian, as may be appropriate according to WIC Section 305.5. Please note concurrent jurisdiction applies when both the tribe and the state court have authority over the child. Confirmation from the tribe regarding transfer of jurisdiction must be documented and guides whether the state court proceeds or transfers a case. As a reminder, concurrent jurisdiction is not only applicable to California tribes, it applies to all federally recognized tribes. Next slide, please. Transferring jurisdiction in cases with concurrent jurisdiction. The process to transfer jurisdiction with concurrent jurisdiction is further described in the California Department of Social Services ICWA desk reference and MPP section 31-136.1. Under the ICWA 25 United States Code section 1911B, a transfer from state to tribal court may be requested by the Indian child's parent, Indian custodian, or the tribe itself. The state court must grant a transfer unless there's good cause not to. A parent objects, or the tribe declines jurisdiction. Please note, statute does not define what constitutes good cause. Please note, statute does not define what constitutes good cause to deny a transfer. Next slide, please. Transferring jurisdiction in cases with concurrent jurisdiction continued. Good cause is not defined by statute. However, the state court cannot deny a transfer based on socioeconomic conditions and the perceived adequacy of tribal social services or judicial systems, whether the child custody proceeding is at an advanced stage. If the Indian child's parent, Indian custodian, or tribe did not receive notification of the child custody proceeding until an advanced stage, it shall not in itself be considered an unreasonable delay for a party to wait until reunification efforts have failed and reunification services have been terminated before filing a petition to transfer. Whether there have been prior proceedings involving the child, which no transfer petition has been filed, whether the transfer could affect the placement of the child, whether the Indian child has cultural connections with the tribe or its reservation. Please note that the above requirements for transfer of jurisdiction apply to both voluntary and involuntary proceedings. Next slide, please. Transferring jurisdiction in cases with concurrent jurisdiction continued. The ICWA-50 form, notice of petition and petition to transfer case involving an Indian child to tribal jurisdiction may be used by a parent, Indian custodian, or a child's tribe when requesting to transfer jurisdiction of an Indian child. The request can be made orally or in writing. The court must issue its final order using the form ICWA-60, order on petition to transfer case involving an Indian child to tribal jurisdiction. The ICWA-60 form is mandatory for court use only. However, failure to use this form should not be used by counties to delay or obstruct transfer of jurisdiction to the tribe or the child to the child. However, failure to use this form should not be used by counties to delay or obstruct transfer of jurisdiction to the tribe or the child to the tribe's custody. According to WIC Section 305.5D, once a tribal court formally accepts a transfer, the state court has specific responsibilities. The state court must promptly provide the tribal court with all relevant case records, which includes pleadings and any other court documents related to the case. In addition, the state court is required to work collaboratively with the tribal court to ensure that all transfer of the case and the transition for the child is handled smoothly with little disruption as possible. Again, exclusive and concurrent jurisdiction are not limited to California tribes. They apply to all federally recognized tribes. When a case is transferred to a tribe located out of state, an interstate compact of the placement of children ICPC referral is not required for the transfer of jurisdiction to the tribe. Next slide, please. Okay, thank you all for your attention and time. If you have any questions, please feel free to come off mute or enter them in the chat. Thank you.
All right, thank you very much.
Thank you.
All right, and I know I see a question in the actual Q&A section too, from Rachel. And this is, I think it goes back a little bit. So I'm not sure, John, if this was yours, but this was about the rates chart presented on slide number 8. And the question, well, there's 2 questions. Is this only applicable for federally recognized tribes? And then also, will the rates charts presented on slide 8 be included in the annual ACLs regarding CNI increases moving forward? Okay. And I do see a thumbs up on there. So thank you for answering that. Sorry to get off track a little bit. Just want to make sure we get all the questions in there. All right, so we'll keep an eye on that and go ahead and move forward. And this one is, my screen's so small, it's ACL 2562, I think. I can't really read it. It's too small on my little laptop. But this is updates to children's advocacy centers, multidisciplinary teams, and child forensic interview recordings. All right, so we'll go ahead and take it away, and you can go ahead and introduce yourself.
Okay, thank you. My name is Amelia Franson again. I just presented on ACL 25-89, and I'll be presenting on ACL 25-62, which is Senate Bill 603, updates to children's advocacy centers, multidisciplinary teams, and child forensic interview recordings. Next slide, please. Okay, purpose and background. This recorded webinar will discuss ACL 25-62. This bill amended Penal Code Section 11166.4 to strengthen confidentiality protections for recordings of child forensic interviews by Children's Advocacy Centers, CAC, and to specify that in the case of an Indian child, the multidisciplinary team associated with the CAC shall include a representative from the child's tribe. Next slide, please. Background laws. California law, specifically AB 2741 and AB 477, supports and strengthens the use of children's advocacy centers and child abuse investigations. AB 2741 added Penal Code Section 11166.4, which authorizes counties to use CACs when investigating reports of child abuse, child sexual abuse, exploitation, or other forms of maltreatment. AB 477 amended Welfare and Institutions Code Section 18961.7 to clarify that a child abuse multidisciplinary personnel team may include a CAC when a county uses a CAC as part of its coordinated response. Next slide, please. CAC operational requirements. Penal Code Section 11166.4b requires any county that uses a child advocacy center to coordinate its multidisciplinary response as prescribed in Subdivision A. When a county utilizes a CAC, the CAC must meet the following standards. The multidisciplinary team associated with the CAC must include a CAC representative and at least one representative from each of the following disciplines: law enforcement, child protective services, district attorney's office, medical providers, mental health providers, and victim advocates. In the case of an Indian child, a representative from the child's tribe, including but not limited to a tribal social worker, tribal social services director, or tribal mental health professional. Please note, members of the multidisciplinary team may fill more than one role within the scope of their practice if needed. Next slide, please. Release of child forensic interview recordings. Penal Code Section 11166.4b9 requires that children's advocacy centers or other identified multidisciplinary team members, custodians, to ensure that all recordings of child forensic interviews are released only to a court order. The court must issue a protective order as part of the release unless the court finds good cause that disclosure of the child forensic interview should not be subject to a protective order. Next slide, please. Release of a child forensic interview continue. If a party does not have an attorney, they cannot receive a copy of the recording. Instead, they must be provided reasonable access to view or listen through official custodian. In criminal cases with represented defendant, a court-appointed investigator may receive a copy of a protective order. The investigator must return the recording to the court when the case ends. When representation ends or the case is completed, all appeals and habeas proceedings must be finished. Attorneys must promptly return all copies of the recording, and that this ensures that the recording is not retained indefinitely. Next slide, please. Exemptions of release of child forensic interview recordings. Pursuant to Penal Code Section 11166.4 B9B, children advocacy centers and multidisciplinary teams are mandated to release child forensic interviews recordings upon court order. However, there are exemptions to this, and there are exemptions for law enforcement officers and county counsel evaluating allegations of abuse. Additionally, the Penal Code 11166.4 B9D allows the CAC to utilize forensic interviews for supervision or peer review as required to meet national standards. Next slide, please. Child Forensic Interview Public Request Act. Pursuant to Penal Code 11166.4 B9E, any and all recordings of child forensic interview shall not be subject to a Public Request Act. The recording shall not become public record in any legal proceeding. The court must order the recording to be sealed and preserved at the conclusion of the criminal proceeding. Next slide, please. Okay, great. Thank you for your attention and time. Is there any questions at all related to SB 603?
Oops.
Okay, I don't see any questions. Thank you all.
All right, thank you so much. All right, so that concludes today's webinar. I want to thank all of the presenters today and giving such valuable information. So thank you again. In the chat, I am just going to put a quick link to the short 5-question survey. That would be really great if you could take a moment of your time and just answer those. This page here that I'm showing you is where you can find all of the CDSS, ACINs, and ACL. This is our letter site that are specific to CDSS. We also post all the recorded webinars. If you missed a previous one, there is a website where you can go back and watch a previously recorded webinar. This one will probably be up in about a week or two. We have to send them out to a vendor for closed captions, and then I usually post that in about a week or two. And then there's just a link to that survey. I got a note. Hi, the survey states it's not accepting responses. Oh, thank you. Okay, I will, I'll follow up with an email if that survey link is not working. It looks like a bunch of you are having the same issue. Apologies for that. I'll go ahead and download a attendee list. And for those of you that did not receive the slide deck, I'll resend that, but I'll also be sending you the proper link to the survey in just a few moments. So thank you for letting me know about that. Apologies, I'm not sure why that's not working, but I'll take a look at it. All right, so and then the next policy guidance webinar we tentatively have scheduled for August 20th. Typically, I will send out a MailChimp newsletter letting everybody know which letters are going to be covered, what the date and time is. If you are not on our registration list to receive notices about upcoming webinars, there is that URL on the bottom of the slide deck, and you can sign up to get future notices. So thank you very much, everybody. I'll hang out just for a few minutes, see if there's any last minute questions, but other than that, everybody happy Friday Eve and have a good rest of your day. Thank you. All right, I see someone had the no issue completing the survey, so that's great. I will double check, maybe the one in the chat was incorrect and the one on the slide deck is correct, but either way, I'll fix that. Thank you again, everybody, and have a wonderful day.